Good morning, everyone. My name is Maria Clayton, and I'm a manager at MMP, working out of our Cambridge office. I am delighted to have the opportunity to address you for a few moments and introduce our speaker for this morning. MMP is the fastest growing national accounting, tax, and business consulting firm in Canada. We proudly serve the response of the needs of our clients in the public, private, and non-for-profit sectors. Through partner-led engagements, we provide a collaborative, cost-effective approach in doing business and personalizing strategies to help organizations succeed across the country and around the world. We are proud to support organizations like the Chamber of Commerce and partnership our alignments with our business and spirit and amplifies our values of leadership, excellence, and commitment in enhancing our community where we live and work. This morning, I'd like to introduce Tushar, who is an associate from Gowing WLG Employment, Labor and Equality Group. His practice focuses exclusively on management side of employment. Sorry, let's try that again. His focus is exclusively on management side of employment, labor, human rights, and privacy law. He served clients all across industries. Tushar advises on the board range on contentious human resource matters, including with respects to onboarding, growth management, policy review, statutory compliance, employment litigation, labor arbitration, workers' comp, occupational health and safety, privacy, and data security. And he also does restructuring and entrenchment as well. Please welcome Tushar.
Thank you so much, Maria. I'm actually joined today by one of my colleagues and close friends here at Gowing WLG. Her name is Hina Gauss. And Hina and I are going to be talking you through a couple of recent legislative changes that have been a source of quite a lot of discussion over the course of the last several months. And we've got a compliance deadline coming up. Thank you so much, Province of Ontario, on the Tuesday after the Thanksgiving long weekend. And so I'm actually just going to share my screen and start us off on a slideshow. Okay, are you able to see my slideshow over here, Hina? Are you able to just give me a thumbs up? Thank you so much. All right. So a quick introduction to my colleague, Hina Gauss. Hina, do you want to say a couple of words?
Hi, everyone. My name is Hina, and I work with Tushar in the employment department here in our Waterloo office. It would have been nice if we could see all of you today, but we're still doing things virtually. But we're basically just going to cover Bill 88 today, and there will be a period at the end for a question and answer. So if you have any burning questions, save them for the end.
Perfect. Thank you so much, Hina. A quick overview of the agenda and a quick legal disclaimer. What you are seeing today and what we are going to disseminate to you, although we're talking about legal issues, this is not specific legal advice. If you do have specific questions about your workplace and your specific workplace needs, please contact an employment lawyer. We were happy to be your employment lawyers if you do not have employment lawyers, but please do take the time to obtain specific legal advice. So Bill 88, we're going to do a quick refresher. We've spoken about Bill 88 with the Chamber before, so a partial refresher, but also just verifying where we landed. We've also got a couple of other agenda items that are related to Bill 88. So the Employment Standards Act, electronic monitoring policy requirements, what do we do now, which is it seems to be a great question these days, and best practices. So how to draft, how to finalize, practical considerations when you are creating your electronic monitoring policy. And then finally, as Maria had mentioned, we have a question and answer period. And so why don't we dive right into a poll? So we've got a couple of poll questions, and I'm hoping, Greg, that we can pop these up for the attendees, get a little bit of audience participation. The first poll question is, have you heard of Bill 88? Is this all news to the folks here? Second poll question, true or false? Bill 88 only deals with employee surveillance and electronic monitoring issues. And so we will give everyone a little bit of time to respond. And so, have you heard of Bill 88? We have a strong contingent in the yes column, so that's good because we're on the eve of the compliance deadline for electronic monitoring, and so that's fantastic. For the second poll question, the true or false, is there a way to see, there we go. Bill 88 only deals with employee surveillance issues. That's a tough one. It's kind of a trick question. Okay, let's see how the folks have responded. False, 100%. I think I might have given away the answer a little bit, but that's okay. We're here to share. So absolutely correct. Hina, do you want to dive us into that that true or false question and what Bill 88 actually covers? Because there's more than electronic monitoring to this legislation.
Absolutely. So when you hear of Bill 88 today, you do hear of the electronic monitoring policy, especially because the compliance deadline is upcoming. But Bill 88 actually makes several amendments, not just to our Employment Standards Act, but also to multiple other acts that are unrelated to employment directly. So for example, there's the Digital Platform Workers' Rights Act. This is a whole new act that's established by Bill 88. And what it's meant to do is to establish certain worker rights and protections for workers who perform digital work. Now, this is regardless of if the workers are employees. It'll also apply to digital workers who are contractors. The scope of this Digital Platform Workers' Rights Act is that it's applicable to online platforms that allow workers to choose or accept or decline work. So when you think of things like a rideshare application on your phone, things related to delivery, courier, and other services, that kind of platform would be covered by this act. Now, the act includes a range of information that an operator must provide in writing to a worker. It establishes some key rights in this respect. For example, a worker would have a right to the information regarding how their pay is calculated, as well as information about tips and gratuities and various factors that determine work assignments and performance ratings. If there is a performance rating system, this act says that if the worker needs to know if there's consequences based on the worker's performance rating. So it creates a sort of transparency requirement in a sense. And it also has some new record keeping requirements and offenses. Now, we won't go too much into this act because it's actually not in force yet. So this new act comes into force on a day that will be proclaimed in the future. But right now, it's available to review, but there's no deadline for when these things will come into place.
And maybe I can jump in here, Hina. So speaking of things that are not yet in force, we may remember that there was some discussion back in March, April of naloxone and what is naloxone and what is a naloxone kit. You'll see that under the Occupational Health and Safety Act bullet here. So naloxone is essentially a drug that will provide someone who's experiencing an overdose, an opioid overdose, with valuable additional time in the event of an overdose to allow an ambulance or first aid to arrive. And so the province has implemented certain provisions into the Occupational Health and Safety Act, which are to take effect on a day that has yet to be proclaimed, so not yet there, for certain new requirements relating to naloxone. Certain workplaces, if you conduct a risk review and an audit and you find that there's a high risk of an overdose, so the province has designated a couple of potentially captured workplaces, construction sites, bars and nightclubs, just to name a few. At those specific workplaces where there's a high risk of an overdose, we've got to have a naloxone kit that is functioning. We've got to train the employee, et cetera, and so forth. Not yet in force. You're going to see a lot of coverage on this when it does, in fact, come in force, but that's also folded into the wrinkles of Bill 88. We've also got a substantial increase in penalties and a doubling of the limitation period under the Occupational Health and Safety Act. In some cases, the penalty thresholds have gone up by 10 times. Those took effect on July 1st of 2022. And there's also new legislated and sentencing factors, aggravated sentencing factors for companies, individuals, workers, et cetera, supervisors, managers, directors who contravene the OHSA and who basically have to go through this system with the courts already. It's nothing really all that new from where we're sitting, but now it's in the statute. Do you have a prior history? What were the circumstances? And did you ignore something that was so blatant, like fall arrest safety or something along those lines? So these factors were already implemented under common law when people were being sentenced for violation of the OHSA. Now they're in the statute. And so maybe we can jump forward, Hina. Do you want to walk us through just very quickly, because I think our primary focus is on the electronic monitoring side, but maybe these two changes here, the Fair Access to Regulated Professions and Employment Standards Act changes on leaves and business consultants.
That's right. So another act that Bill 88 makes changes to is the Fair Access to Regulated Professions and Compulsory Trades Act. Now that is a real mouthful, so I'm just going to call it FAR-PACTA. So what Bill 88 does is that it amends the timelines within which regulated professions have to respond to applications for registration from domestic labor mobility applicants. So what that really means is workers who are applying for registration with a regulated profession in Ontario to a currently registered body, they need to get permission and they need to apply to Ontario. And what this act does is it streamlines the process. So it allows the person to apply, a person who's from a different province or territory in Canada, to apply to the regulated professions that are listed in FAR-PACTA. So what really is a regulated profession? I won't go into it too much, but the act does cover about 23 trades and 14 regulated professions. And that's what the changes that Bill 88 makes. It addresses all of these trade skills and professions as well.
Interesting. So then we've got the Employment Standards Act changes. And again, just to call them out at a very high level, there are new rules that relate to minimum standards and rights for business consultants and IT consultants. Now, noting that we want to focus on the electronic monitoring and employee surveillance, if you will, aspects of Bill 88. I'm just going to call out that there are these new rules, there are these new rights. What we'll do is we'll circulate an online article that was published on Gowling's website, and we can disseminate that to the audience, and they can review these in detail. There are also new reservist leave provisions under the ESA that'll kick in, or that did kick in on April 11th of 2022. And so a couple of things to be mindful of, and we'll circulate more resources on this so that you can peruse them at your leisure. On the next slide over here, we've got another poll question, Greg. And so, true or false? All Ontario employers are required to establish an electronic monitoring policy to comply with the Employment Standards Act. This is an interesting question. Okay, let's see how the folks responded. 50-50 almost, 47-53. Okay, interesting. So Hina, what's the answer to this question?
Yeah, so the answer is it's false. And I think when Tushar, you were reading the question, you emphasized the word all, and that's really the trick in that question. It's not all employers that have to establish this electronic monitoring policy. So the Employment Standards Act was updated with this new section that says that if the employer has 25 or more employees as of January 1st of any year, then they need to have a policy on electronic monitoring. Now, the first year that this legislative change was introduced this year, you have to have a policy in place by October 11th. But going forward, if you have 25 or more employees on January 1st of any year, you need to have that policy in place before March 1st of that year. Now, the scope of this is that it also applies to only provincially regulated employers. So it wouldn't apply to employers that are subject to the Canada Labor Code, which would be federal employers. And it also applies to all employees. There are no exemptions other than Crown employees. So that means whatever your status or industry, you do need to have this policy in place if you meet that 25 or more employee threshold.
So, I'm the CEO of my company, Tushar Inc. And am I included in the count? I'm the CEO. Am I subject to this policy? Does it apply to me?
It does apply to you because you can be electronically monitored and it's part of the 25 employee count. So if you're a CEO, if you're a part-time employee, so a part-time employee counts as one full employee, just in case that was something people had in the back of their mind. So if you have 2 part-time employees doing the work of 1 full-time employee, that's a count of 2.
And what's interesting to note as well is we've got a reference point of January 1 of the given year. It doesn't say regularly employed throughout the year, as we've seen with some other legislative requirements. And so January 1 of a given year, we have 25 or more employees. There are some seasonal employers that may have 6 employees in January, but 156 in June. And so theoretically, those individual employers wouldn't be captured. But there's nothing really stopping the employer from opting into this and bringing themselves into compliance with the requirement. It's good practice for various reasons that we're going to get into.
So
And so
Tushar,
maybe you
just a
can walk us through.
question.
Yeah, of course.
Yeah, so if an employer has 23 employees on January 1st, but a couple days into the year, they have more than 25 employees, do they have to have a policy?
Technically, because it's not on January 1st of that year, I think the answer is no. But by the same token, as an accountability issue for your staff or an employee relations issue, do you want to introduce a policy if you're going to cross that 25 threshold regularly, or maybe you're just close? There's nothing stopping an employer from doing that. And again, I think it's good practice. And so, okay, fine. So, let's say we are either forced to create a policy or we want to create an electronic monitoring policy. So what does the legislation actually require us to have in the policy, Hina?
So the legislation is not very clear about what it requires. It has vague words, it's somewhat ambiguous, but this is what it says it has to have. It says you have to say whether you electronically monitor employees. If you don't electronically monitor employees, you need to say so in your policy. But if you do electronically monitor your employees, then you need to provide a description of how you electronically monitor. Not only how, but then you also have to go into the circumstances in which you may electronically monitor your employees. Apart from that, then you go into the purposes for which the information that you obtain through electronic monitoring could be used by the employer. So all of these, the whether, the how, the circumstances, we don't have too many details on what it means, but this is what it says in the legislation.
And we do have some examples that we'll walk through that the ministry has published since this legislative requirement was announced way back in the spring. Now, a couple other pieces that we have to include in the policy was the date that the policy was prepared and or modified. And then we've got the usual such information as may be prescribed that we see in a lot of Ontario legislation. It's just the flexibility provision that allows, the Ministry of Labor to say, here's a code of practice that governs how you create this policy. This is a new requirement. And so this is a good idea on the province's side because we're one of the first jurisdictions in North America that has this type of a policy requirement, this specific electronic monitoring policy requirement. So we might see changes in the future. Okay, time for another poll question. True or false? Bill 88, this new electronic monitoring policy requirement, and I'll put up the previous slide just briefly so you can see whether the employer monitors, how, circumstances, purposes, etc. So it creates a new employee right to privacy under Ontario law. True or false? I feel like we need some music to go along with our poll Q&A period. Now I'm curious to see what everybody says in response to this question because there's a lot of information out there. Okay, 50-50 pretty much. And so interesting. Hina, please tell us the answer.
The answer is false. So this electronic monitoring policy, Bill 88, it does not create any new rights for employees. So it doesn't say an employee has a right not to be electronically monitored. It does not create any new privacy rights. So the employment standards requirements are limited to requiring that certain employers be transparent about if they monitor employees. So I know there's a lot of confusion out there, especially for employees. They think with this new legislation, they can say, no, I don't want to be monitored in this way, but that's not what this legislation does. So it's really a sort of transparency requirement, which is what we've been seeing a lot from the province. And there are no new privacy rights from the legislation, but when you're drafting your policy, you have to be careful not to create new privacy rights within the policy itself. It's always possible for an employer to give an employee greater rights than the minimum of what's required in the Employment Standards Act.
And we talked about this once upon a time, Hina, when we were looking at the right to disconnect. And so we were looking at the right to disconnect and the disconnecting from work policy requirement. And you know, you want to be mindful of potentially creating what's called a contractual right. And so that's a great observation. Now, another question that comes in is, okay, so there's this new policy requirement and we've got a large binder that all of our new staff have to read through when we start. Does it have to be its own document, or can we make it part of our handbook or policy manual or whatever we want to call it?
So it does not have to be a standalone document. It can be part of a big policy manual, a big thing that everybody has to review. But what we do recommend is that you compare and contrast it to an acceptable use policy if you have one. So policies that deal with the similar or same aspect as the electronic monitoring policy should be cross-referenced. Now, it might be just easier to have it as a standalone document. You know, that way you can make sure if you ever have to produce it to the Ministry of Labor, you can just give them one document instead of a binder, but it's not actually a strict requirement to have it be its own standalone document.
Interesting. So it might just be more user-friendly if we have it on its own. That's interesting. So we have some new commentary from the Ministry of Labor, and we didn't have this last time around. And so we thought, you know, let's get into the examples here. And so here's something that comes up under the heading, whether the employer engages in electronic monitoring of employees. So a critical piece here is electronic monitoring includes all forms of monitoring that are done electronically. And they've given a couple of examples of what I think are, they're a little bit confusing, but I'd like to get into this. So GPS, and that's pretty self-evident, right? If you're tracking location, you know, you've got LoJack systems or whatever the tracking systems are in company vehicles, et cetera. You've got your RFID scan cards. If you come into the office and you have to scan in, that kind of technology is there. Tracking websites employees visit during working hours. That is another sort of perhaps automated form of monitoring, right? If there's a specific class of websites that is not permitted during work hours and IT implements monitoring techniques to make sure that those aren't accessed, websites that could create security vulnerabilities, et cetera. That is a form of active monitoring, even though it's done primarily by you know, a computer or AI or whatever the case is. But I want to draw out the distinction here because these sound like active forms of monitoring. What about the passive forms of monitoring, Hina? So I am using Outlook or Gmail or whatever the case is to actually send out communications from a work-related computer, and there isn't really anyone sitting at the helm of this, you know, device saying, oh, you know, is this wrong or right or whatever the case is. But if there's a harassment complaint or a criminal investigation or something that has to happen after the fact, I can get that information. Is that monitoring in a sense?
So the legislation doesn't distinguish between this active and passive monitoring. So yes, that would fall under, it is monitoring overall. What I find a little frustrating is the Employment Standards Act itself doesn't provide a definition of electronic monitoring. The circular definition that you do see here, you know, includes electronic monitoring is electronically monitoring employees. That comes from the Ministry of Labor's sort of guidance document. So it's not legally binding as a definition itself, but it's guidance, if you can even call it that.
And that's interesting. And I'll add to that a couple of other sources of frustration here is that we don't have a limitation of scope, right? So this is not limited to a corporate issued device, such as a phone or a laptop or something along those lines. In theory, any form of electronic monitoring that could be captured actively or passively is captured by this big net definition that they have deployed under the statute. The other thing to keep in mind too, as we deliver this virtual webinar, is that electronic monitoring is monitoring that happens at the workplace, but the bounds of the workplace extend clearly into the virtual space. And so if an employee is in Hawaii and they're sending emails from their corporate device or even via their phone with a corporate profile, that could still be captured under electronic monitoring legislation and meet the definition of monitoring under the statute. So let's shoot over to the next example. So tracking employees' delivery vehicle using GPS, right? So here's the sort of the textbook example that the ministry's provided us, Hina. So how the employer monitors the employee's movement by tracking the delivery vehicle through GPS. Circumstances, the employer monitors the employee's movement in the vehicle for the entire workday, every workday. Purposes, the employer uses the information obtained to assist in setting routes for employee safety, to ensure employees do not deviate from their delivery route during the shift, and to discipline employees who are untruthful about their whereabouts during working hours. I would actually add to this. I would say that there are other purposes such as third-party investigations, insurance issues, etc. So this is the kind of exercise that the ministry is expecting an employer to go through with respect to each, let's call it, asset. So the delivery vehicle has GPS. The GPS is an electronic asset. Can we frame it that way, Hina? Is that a good way of looking at this?
I like that way of looking at it, because when you look at an asset, it can include the passive and active monitoring. It can include software on computers. It can include hardware like a GPS. So that sort of a broad definition is in line with the lack of definition of what electronic monitoring is.
Interesting. Okay, let's look at another example. This one was kind of textbook, right? So this is probably something that would affect more of the folks that are on the call with us. So monitoring employees' emails and online chats. How? Employer monitors emails and online chats through a software program created specifically for this purpose. I don't think it needs to specifically be created for this purpose. Most software of this type has the ability to generate what's called an audit trail. And so it moves it from, oh, this is a specifically created tracking software to this is an asset. I think that's a better way of looking at this. So circumstances. The employer may, I think that's the key there, may monitor at any time, including retroactively, employee emails and online chats. Purposes, the employer uses the information obtained through electronic monitoring of employee emails and online chats to evaluate performance, ensure appropriate use of employer equipment, and ensure work is being performed during working hours. So Hina, this is kind of similar to the GPS example. It's about as broad a definition or example as you could possibly come up with.
Mm-hmm. And there's a reason that I think that the ministry didn't go into extreme detail with each aspect. They didn't say what kind of software program. They didn't, list out the model and the make of the GPS system. And the reason for that is having a more generic level of disclosure is it actually prevents sort of nefarious activities from happening. It prevents someone from, for example, hacking into the GPS and altering it. It protects against security threats for whatever software that one might use. So we want to be sure that we don't disclose too much information in the how and the circumstances to avoid to open up any risks for the organization.
And here's that's a fantastic observation. I'll advance the slide so we can chat about this a little bit further. And I think we'll come back to over disclosure as a theme. But there's nothing in the legislation that says, I'm using name of software, name of antivirus 2022 edition. There's absolutely nothing saying that is required. And if you look at the examples from the ministry, they're drafted very generally and at a high level. And so I think that is implying that we have the ability to alleviate the risk associated with over disclosure. Whereas if we were to put, name your antivirus software 2022 into the policy, it creates a vulnerability for employees who may think that there's a way to exploit or get around something. Okay, so that's interesting. What do we have from the Ministry of Labor on restrictions in terms of use? Really not all that much. The ESA and Bill 88, they don't really restrict or limit an ability of an employer to use the information that is obtained through electronic monitoring, active, passive, and everything in between. It doesn't say that we cannot use this for an investigation or for a for-cause termination or anything along those lines. Interesting. Are there privacy considerations that might come up? We really don't have much on that in terms of the ministry's guidance. Now we have some comments of our own that we'll get to, but nothing really from the ministry. Common law considerations, right? The common law considerations relating to privacy in the context of employment, the principle of consent before obtaining information. None of that is found in here. Warnings and relying upon information for disciplinary reasons. Nothing really in here. And what if you're unionized and there's a collective agreement which steers you towards or away from certain types of techniques? Really not all that much in the ministry's guidance. It's very, very high level. Is that fair, Hina?
I would say that's fair. Yeah.
Okay, why don't we move on then to additional legal concerns? Maybe you can walk us through some of the interaction between what we now have in Ontario for Ontario, private sector ESA regulated employers versus what we see in other jurisdictions.
Mm-hmm. So Bill 88, it does make changes to various acts in Ontario, but there are a lot of employers and organizations that have operations in multiple provinces. So there are several Canadian jurisdictions that have private sector privacy legislation that's apart from their employment standards legislation. And this, for example, there's Quebec, there's Alberta, and there's British Columbia. They all have their own privacy legislation, which regulates employee information. Ontario does not have a similar private sector privacy law that applies to employees. The federal employees do have a private sector law. It's called PIPEDA, and there's also other applicable public sector statutes. So the rules that apply in Ontario would not be the same that would apply to your other operations, especially in these other provinces. And this is a bit challenging because Canada does have a patchwork of privacy laws. It can create challenges for multi-provincial employers to achieve compliance. So if you have your electronic monitoring policy in Ontario and it's in compliance in Ontario, it doesn't mean it'll also be in compliance for all these other jurisdictions you may have operations in. The rules can be substantially different in some cases. For instance, in Ontario, there really is no requirement to obtain this explicit consent of an employee for being monitored. In other jurisdictions, there is. So if you do have operations in multiple jurisdictions, we strongly recommend that you seek specific legal advice just to make sure you're compliant in each jurisdiction.
Particularly Quebec, because you might have to translate the policy into French. So
Yes.
there's a specific legal compliance obligation that could apply even if you've got employees in that province. And so just to touch upon these quickly, we mentioned them before. The common law does have implications with respect to privacy, and that comes from Supreme Court case law where employees may have a limited right to privacy in the context of the workplace. The common law deals with things in a different way than statute, though, right? So our focus will be on the statute, but that is also out there. And so Bill 88, again, does not really touch upon these things. The other thing to keep in mind is, perhaps you do have a contractual right that's created under a collective agreement, under a policy that would tend to conflict with the statutory requirements. And so again, inviting the attendees today to get specific legal review, if you are one of these employers where these considerations apply, if you're unionized, if you've got, policies that create and carve out specific zones that employees do have this right to privacy. We generally recommend against doing that, but in case you have, that's something you want to be mindful of. And so just very briefly, we talked about some gaps in the legislation. We've been flagging them as they come up, Hina, but we really don't know if there are carve-outs or exemptions for certain business functions. So, is there a carve-out or an exemption from calling out a specific type of monitoring if it relates to security, for instance, IT infrastructure? There's nothing on that. We talked about active versus passive monitoring. And then we also talked about the extent of the requirement to disclose and put employees on notice of the policy requirements. But again, we don't see a whole lot of guidance and no indication that we have to be very specific with employees about the how and the why and the circumstances and all of that. Is that a fair statement?
That's a fair statement. So in terms of the carve-outs, While there's nothing right now, there is a provision that says the lieutenant governor and council can make regulations that provide for certain carve-outs. Now, I had hoped when this was introduced back in April that the ministry would release some guidance about carve-outs. You know, there's carve-outs for different parts of the Employment Standards Act in different industries or different positions. I was really hoping there might be carve-outs for something like healthcare, finance, but any of those sectors, but we have nothing so far. It can be created, but there's nothing at present about, you know, any industries or positions that are carved out. There are no exemptions yet.
Interesting. Okay, so we've talked about some practical considerations, and we want to be mindful that we want to leave as much time as we can for Q&A at the end of this presentation. So maybe we can just move through the practical considerations very quickly. We've talked about picking the right level of disclosure. Don't tell them the make and the model of the vehicle. There's no requirement to do that under law. You know, we need to be mindful of over disclosure that can create a security risk. Anticipate questions from your staff who may read the definition and say, hey, I have a right to privacy in the workplace, and be ready to deal with those particular questions. Create and maintain your asset map. Determine how the employees are being monitored. You cannot implement this policy unless you know what the playing field looks like and where the goalposts are. We have had many discussions with clients who have gone through the exercise of actually mapping out their assets, and they are surprised by how many unmanaged apps or devices IT has flagged in the course of the review. That's a great exercise, completely aside from these electronic monitoring policy compliance requirements, because you're actually plugging holes in your IT infrastructure and security. And I think on the back end of all of that, as you move through all of that prep, you're preparing and you're finalizing a policy. Okay, fine. October 11th is a Tuesday after Thanksgiving, but you actually have 30 days from October 11th, as Hina had pointed out earlier, to get this policy into the hands of your staff, right? So that puts us into November. And so we've got staged compliance. Minimum viable product on October 11th, and by November, you should have plenty of runway to actually meet with IT, build out your asset map, root out those unmanaged apps, and move forward. Hina, maybe you can talk us through interplay between the policies that we referenced earlier. You talked about cross-referencing.
I did, yeah. But just one thing I wanted to say about connecting with IT. I know that seems like a lot of work, but I think it's especially important considering how a lot of employers had to rush during the pandemic to remote work. This created, employees working from home on their own devices at levels that didn't happen before. Sometimes employees work from using public Wi-Fi. So there's all these new issues that come up that weren't really considered before. And so it would be important to connect with your IT department on that. So continuing with the practical considerations, I did mention that you should cross-reference your electronic monitoring policy with other policies you have in place. It does, like I said, it does not have to be a standalone policy, and it is possible to take something like your acceptable use policy, or if you have your own privacy policy, and either incorporate it into your electronic monitoring policy, or at least link them so you know that they're compliant with each other. A lot of employers also have things like a mobile device policy. That's also something you would want to cross-reference with your electronic monitoring policy. Some employers provide employees with a business mobile phone, but other employees are allowed to use their own phone for work-related purposes. So we would recommend getting into detail about if an employee is going to be monitored on their own personal phone when using it for work purposes. Aspects like that would be helpful if you got further information from IT, and that's why we recommend you still have some runway. I know October 11th is soon, but to get this policy into the hands of the employees, you have a bit of runway left.
And so again, before you get started, what is your organization actually doing? We got to figure that out. Talk to IT. Create your draft policy. Do you electronically monitor? I think if you use email, you monitor. And a lot of folks, we've had this discussion, and they come in and say, really monitor. No, it doesn't mean you're sitting there and watching people on a camera. That's not what this legislation means. You got to put that out of your mind. You need to be mindful that most, if not all, forms of electronic communication, if there's a tie into the workplace, are captured by this form of monitoring. There's a way to get them after the fact. You're monitoring. So keep that in mind.
Yeah, I have an
Especially if you receive
example.
pushback from IT.
Absolutely. I have a good example of that. I had a client that said, we don't electronically monitor. And then I said, okay, do your employees use something like Slack to communicate with each other? Yes, but we don't look into it. Do you have the ability to pull the Slack messages? They're like, of course we do. It's on our system. And I'm like, okay, that could easily fall into electronic monitoring. And so then we had to go through the whole process of what other devices and softwares are like that.
Absolutely. Text messages between an employee and a supervisor, from the employee's personal phone to the supervisor's work phone. You can get access to those text messages. You are electronically monitoring. Thank you, Province of Ontario. So that is how broad the net is. And so when we're creating this draft policy, we want to provide these examples at a high level, and indicate those in the policy so that employees are not confused, and so they're aware. Again, this is a transparency requirement. This is a we are doing X requirement. It is not so much a can we get your permission to do X requirement. It is a look at what we're doing. We're being transparent about it. This is what the legislation requires at a high level. That's a sort of, if I can put it in a nutshell, that's what it is. So defining the purpose of the monitoring, grouping purposes together, and saying we use these documents and these types of data and these particular assets for all of these purposes, productivity monitoring, et cetera, as we talked about from the ministry's examples. And so one thing we'll do as well is, I know this is a lot of information to pack into a short webinar, but we will circulate our slide deck as well so that you can see these specific examples. And the ministry's examples as well will share the links to the ontario.ca website where they've actually posted those hypothetical situations. And you'll be there if they post new examples as and when these issues come up and evolve. And so define your purpose. We talked about that. Define your scope. Cross-Canada operations. Do we need a Canada-wide policy? Talk to your folks. Application. It's all employees. Do we have temporary employees? There are specific rules and requirements that relate to temporary employees. Are we dealing with office, remote, and hybrid staff? These are things that you may want to flag for further review and discussion. Who can review and who has access to the information and when? And then enforcement mechanisms under the policy. We recommend just a boilerplate statement. Would you say, Hina? So something that says any breach of this policy may result in discipline up to and including ...
Absolutely. And the reason for that is if you want to be able to rely on your electronic monitoring policy for discipline, you want to say directly in the policy that you can do so.
Absolutely. And again,
yeah,
we're putting people on notice. We're putting people on notice. So, and maybe we can talk about this before we dive into the Q&A, but there was an interesting case that maybe gives some fuel to the, it's a BC case, and we'll get to it, but it provides some motivation, let's say, for employers to get on side of these issues. Another really practical observation, and maybe you can talk through this one, Hina, because we've seen policies that just say, this is the policy, and that's the policy.
So you do want to have a statement in there about the right to amend or replace or revoke this policy. While you might have the policy in place 1 year and not need it in place the next year, many employers keep it anyway, but others revoke it. If it's not necessary, why have an extra policy? So just to put employees on notice about this fact, we would put that directly into the policy itself. Also have information in there about where employees can go if they have any questions. You want them to be going to the right people so we're all on the same page about how things are applied. Now, it's not necessary to have an employee acknowledgement directly in the policy, but just practically speaking, it can be very helpful in the future. An employee might say, I didn't know this was the case. I didn't know I was electronically monitored, or it might be used for these purposes. If you could have a document that was saved in the employee's personnel file that showed, they read it, they acknowledged it on this date, it would be very helpful from an employer's perspective to rely on that in the future.
And so we talked about anticipating questions from staff, the difficult staff questions that come into HR, and what they might say about, oh, I have a right to privacy, this and that. So hopefully this equips you with a little bit of knowledge to sort of respond to those questions reasonably. And then again, if you're consistently over the 25 employee threshold, if you're a medium to large employer, and you know that this is going to be a year over year, we've got to review it. We need to be drawing this to new hires' attention, et cetera. Maybe reference the policy manual, handbook, et cetera, in the employment agreement itself, the terms of employment for the individual. Not a bad idea in the circumstances. Copies and provision of these documents to staff. So we've got to give them over to both existing and new hires, and there are different timeframes relating to those categories. Temporary help agency employees. We mentioned that there were a couple of wrinkles, and just mindful of the time and wanting to sort of reserve as much as we can for Q&A. Those are actually dealt with on the ontario.ca website. So maybe we can kind of breeze over that point. Hina, I haven't got a policy in place, and I have 26 employees on October 12th. You know, what's going to happen to me as an employer?
So if you had 26 employees, January 1st of this year, and then you didn't have a policy in place by October 12th, and then another 30 days went by and you didn't provide anything to your employees like you were supposed to, what could happen is the Ministry of Labor could stop by and say, employer, where is your electronic monitoring policy? And if you don't have something in place to show for it, there are, you know, a variety of things that can happen. You can just get a slap on the wrist, you could get a fine, you could get an order to tell you to have this policy in place. So just to avoid an inspection from the Ministry of Labor, and also to avoid potential complaints from employees. I mean, employees talk to each other, and if there's other workplaces where they're introducing an electronic monitoring policy, an employee might say, employer, where is ours? We have over 25 employees. I want to see how I'm monitored as well. So these are just things to keep in mind about where the pushback could come from, not just the Ministry of Labor, but your own employees as well.
Absolutely. And then be mindful that from a record keeping standpoint, we've actually got to keep copies of this, right? So copies of the policy, the revision date, et cetera, all of that for a period of 3 years after the policy is no longer in effect. And so it's just come into effect. You know, we won't be looking at this too much, but for 3 years after it stops being in effect, whenever that date may be. So another thing to be mindful of. And with that, I think, Greg, if we can invite you in for some Q&A. We've disseminated a lot of information, and I promise I won't forget about the BC story. Maybe I can share that quickly and maybe lead into our Q&A. BC Employer, the Insurance Corporation of British Columbia. There is a statutory driver's licensing scheme in insurance scheme, excuse me, in that province, and so there is no private insurance there. You just go through the province, and there's a series of criminal issues that come up several years ago where members of law enforcement are directly targeted by organized crime at their homes. Their property is damaged, they're personally harmed. And it comes out during the course of the police's investigation that the criminal entities had an employee on the inside of this insurance corporation, the British Columbia government, essentially, in this crown corporation. And so the individual on the inside admits that this is all sort of what happened. I got the information from through the context of my employment, and I sold it to organized criminal agencies and entities, and they then use that information to go and target these third parties who were very unfortunately the victims of all of this activity. The Insurance Corporation of British Columbia, as of last week, there was a class action certified saying that they, the employer, were liable for the activities of their employee who went rogue and who accessed all this information because they did not put in a gatekeeper and were not monitoring to see what was going on in this particular context and setting. Scary stuff, right?
Yeah,
so that class action was just certified.
What level of judiciary made that decision? Was it the Supreme?
That's the first line, right? That's the BCSC. So our equivalent of the Superior Court in Ontario.
Mm-hmm.
Yeah.
So we may have to see what the Supreme Court, because I'm quite sure the employer is going to be all over that. But I have just a quick question. We do have some questions coming in, and I hope everybody will use the Q&A portion at the bottom of their screen to ask some questions, because we only have a few more minutes. But you know, I think what really interests me is the fact that this, when you talked about the size of the company, and we talked earlier, I think a couple of sessions ago, where we talked about, whether you're 25 employees or not, it's probably a good idea to have something. Simply because we are all monitoring. We all have email that's connected to the business. So whether you're 10 employees or 1,000 employees, you're monitoring in some way by just having access to the data that's there. So it's probably a good idea. But what about remote working when, and I know you said get the camera idea out of your head. It's not about cameras, but that's electronic monitoring as well. And, I think there's some piece of legislation that says if you're going to have cameras in the workplace, you can't record the audio. You can only record the video. And what I'm wondering is the conflict between this legislation and other legislation that protects people's privacy.
Well, it's interesting you mentioned that, Greg, because I want to sort of expand on that a little bit further, and I'd have to look at that other legislation because I have clients. Hina's got clients. We've got clients that do both, right? They've got dash cameras, for instance, on company vehicles that are pointing at the road and they're recording video, audio, and they can hear when the driver says, "Hey, buddy, do you want to go for a race?" And then there's a street racing incident or something like that, and real story. And so there is that. So as far as I know, and particularly under Bill 88, there is no constraint. And even going a little bit further than that, on a personal level, as long as one of the two parties in the relationship knows that there is a recording taking place, you can use that recording as evidence in a court of law, right? That's based on Ontario law. And so as long as one of the two parties or one of the many parties in the interaction or in the equation know that this is happening, they can use that evidence for legal purposes. So, I mean, at the end of the day, I think the general thrust of this is not to restrict. Now, that doesn't say there's some other restriction under another statute. There may be very specific rules that apply, for instance, under federal regulations to specific contexts at an airport or whatever the case is, but not under Bill 88. Not from what we've seen under the ESA.
Yeah, I just think, there needs to be some work on this. So maybe I have to speak to Monty McNaughton about this and just say there needs to be some work on this legislation because there are blank spots from all of our perspective on what we're doing and what we're doing right and what we're doing wrong. There's a question here. Hi, a great presentation. They said, if we have an electronic monitoring policy as a part of another larger policy, based on the lack of clarity in requirements, are we still complying?
Yeah, so what I would say is as long as this other policy meets all the requirements of an electronic monitoring policy, do you electronically monitor? If so, how and in what circumstances? As long as it makes those kinds of things clear and the other requirements, you can just have that other policy. I would recommend throwing something like calling it an electronic monitoring policy, or at least addressing that and defining it, but you don't necessarily need a separate standalone electronic monitoring policy.
That's a great call out, Hina, because you don't want to be counterpunching unless you need to. And so if we can call it what we're intending it to be called and what the statute requires us to call it, and we can call it a subsection or a subparagraph or whatever the case is, we're getting ahead of potential issues and it really doesn't cost anything.
Here's a good one, because we utilize this as well. Should we mention clocking in and clocking out using facial recognition as a way of monitoring for payroll purposes?
Oh, you can take that one, Hina. That's a great question, Karen.
When I think about the broad circular definition of electronic monitoring, to me, this falls within that. You electronically monitor employees this way. Could this be relied on for any reason? Yeah, you can say someone wasn't in when they said they were supposed to be in. So yes, is my short answer.
And do we have to say facial recognition? I think that's a sort of logical offshoot of that question. I don't think we do. I don't think we do, because facial recognition or a thumbprint or whatever the case is, that's a form of biometrics. right?
Yeah.
Biometrics, and we can just lump them together under the category of biometrics if we need to. And that kind of ties into our discussion of under versus sufficient versus over disclosure, right? So if we say we're monitoring for payroll purposes, I think that's probably under disclosure. If we say we're monitoring using biometrics for payroll purposes, ... right? In line with the province's examples, we should be good.
Yeah, Karen and the chamber must use exactly the same system, because when the employees register into the clocking in and clocking out program, they have a choice. They can do facial recognition, or they can choose to have a PIN number. And many of the employees just said, "Oh, I'm going to do facial recognition. It's just easier." They push the button, it recognizes them and says, "Welcome to work." So, but I think those are really important things to understand, because we can access that facial recognition. The
Absolutely.
system will tell us that, Greg was at work because here's a picture of Greg that we took at the time he clocked in. So, it's very important stuff. This is, it's confusing, and I'm quite sure as we get along, I quite frankly think, and Hina, maybe you should answer this. When we talk about the company that has 5 employees on January the 1st, and then May the 15th, when, the season opens up for them, all of a sudden they've got 112 employees. At some point through that season, there is a good possibility that the province is going to check in with them and say, "What do you mean you don't have a policy? You've got 116 people walking around here. You have to have a policy." Is that going to be, that's going to be a real challenge for companies to be able to demonstrate evidence that they didn't have those employees on January 1st, but may have had them on January 2nd, but they comply.
That's a really good point that you make, Greg. So if you didn't have those, 25 or more employees on January 1st, you don't have to have that policy in place. But it would be a good best practice to have evidence of how many employees you had on January 1st. So even if you could go into internal systems and take a screenshot of the number of employees you have at all of your Ontario locations, that would be helpful in case the Ministry of Labor comes knocking on May when you have over 100 employees.
Mm-hmm.
And you're giving them less of a reason to pop the hood, right, Greg? Because when they come in, they're asking about this particular new thing. But as everybody knows, when dealing with the ministry or with any regulator, really, they can pop the hood and they can say, "Hey, what's that thing over there? And what's there? Show me the records on this side. And hey, what are you doing with vacation pay?" And so it becomes a bigger thing. So less motivation and less fuel for the fire, if you will.
Yeah, for sure. Well, this is a really good session, and I'm quite certain that that for sure, if people have any more questions, they can reach out directly to you or Hina Tushar, and you're a wealth of information, have been very gracious with your time with the Cambridge Chamber of Commerce, making sure you put on these events for us, and we certainly appreciate that. So you will send out the slide deck. We can get them. Lisa will certainly send them out to the attendees, make sure that they get a copy of the slide deck. But other than that, have a wonderful day, everyone. And Tushar and Hina, thank you very much. You're a breath of fresh air and making something very complex seem maybe not so intimidating. So,
well, we're always happy to be there, and the privilege is ours, Greg. Thank you for having us.
Thank you.
Have a great day, folks.
Thanks all.